Yes, hi everyone. Today, the case that I want to bring to your attention is Mackenzie versus Mackenzie, 2003 EWHC 601 Chancery Division. The house was purchased by the mother, the father, and the son. When I'm saying purchase, they were all joint legal mortgagors under a right to buy, which actually gave the husband, the wife, a right to a discount. Now, something, the relationship between the parent and the child, that was a family home. It got sour due to some personal consideration to fail out, and they wanted to determine the beneficial interest on the joint legal ownership. In this case, the court denied the son beneficial ownership. It denied, and it's quite interesting because it actually raises the financial contributions issue as a freestanding, separate issue, a separate situation under which a constructed trust might possibly arise. The court raises a resulting trust, also a resulting trust quantification, but this is actually it's merely with regards to quantification, and it's before the cases of Stack versus Dowden, which say that resulting trust cannot arise. A resulting trust can only arise at the time of the purchase, and that's what the fifth edition of the Holsters Laws of England states as well. It can only arise at the time of the acquisition. So, a constructed trust, uh, even if it's merely relied on financial contributions in order to allocate property interest, or even if it's relied on or even it's relied on other considerations as well as financial contributions or non-financial contributions, is that's a constructed trust. So the son, it's interesting because the judge goes on to decide whether the son could have had a constructive trust based on his financial contributions, and if he had either a constructive trust or a resulting trust. Now, resulting trust can only arise at the beginning, at the time of the purchase. It cannot arise like afterwards. So what the judge really meant was like if he could have had like either half the share, because by contributing to the mortgage installments of the house, he would maintain his intention to go through with the payments of the mortgage installment, and therefore he would show responsible conduct. And secondly, he said a resulting trust, because even if he couldn't afford to have an equal share, he would his share would reflect his contributions on a mathematical approach. But that isn't a resulting trust. That's not how resulting trust is raised, um, and it's more probably dealt with under the constructive trust principles. Now, the judge basically said that apart from the fact there was no common intention, because on the findings of fact, there was no common intention that the son would have had an interest in the house. Apart from that, had there been no such uh, common intention, had there been only his financial contributions to measure whether he had a share in the house, what kind of share that would be in the light of his joint mortgage liability, then the judge basically said that because he found that he had he was the one who raised awareness. He was the one who prompted the secondary mortgage, out of which he got a loan. That he failed, like he got a loan out of the secondary mortgage, and he was acquiring actually a loan under beneficial interest rates, and also a loan in order for him to buy like a car and some other things, some other personal things that he wanted to. So I know the way that you all looking at it. Like, if he was contributing towards the second mortgage, which the product of which, like, namely, I think it was £50,000, was used, right? It was used to discharge the first mortgage. Like, there was actually a contribution towards the mortgage installments of, the property. However, because the judge, and we don't know here, because we're saying that he's actually examining this issue on a separate basis, right? He's on a separate basis. We don't know if he was affected somehow by the fact there was no common intention that he should have an interest in the property at all. But what we are, but the judge quite intelligently based his separate finding, let's say his separate finding, on the fact that the son was trying to avoid the second loan, right? He was trying to avoid any involvement of his. He was trying to avoid any of his involvements in the second mortgage, right? That he prompted it, because he knew, in fact, that it was a weakness. He knew that it was a weakness in that case, that the judge would have found on the evidence that he was only making the payments because he got £12,000 was out of £24,000, which was the surplus of the secondary mortgage. So that's why he was basically contributing towards the remortgage and then the remortgage under Abbey National. It was because he got something out of it, even even uh, you know even regardless of the fact, despite the fact that he despite the fact that he was contributing towards the mortgage installments, right? Despite that fact, he was only making payments just because he acquired something out of that loan. I'm gonna ahead and read like paragraph 123 of the judgment, and states, I formed the impression that Jim, who is plainly intelligent, was inclined to anticipate whether a line of questioning was going. I formed the impression that Jim, who is plainly intelligent and was inclined to anticipate where a line of questioning was going, was acutely aware that it would be suggested that the Leeds Holbeck mortgage marked a watershed, and it was only when and because the £12,000 was raised for his personal benefit that he began to contribute towards the mortgage payments. As his case has always been and remained that he had also contributed to the first Abbey National mortgage, and that there was no substantive change at the time of the remortgage, he was obviously keen to dispel any suggestion that remortgage was a watershed and to prevent any inference from being drawn from this. I have concluded that Jim was evasive because he knew that it was indeed a weakness in his case, and that the inference he sought to dispel is the truth. It follows that even if I had not concluded that there was an agreement or understanding between the parties which was sufficiently communicated between them in the course of their discussions to the effect that Jim should be a legal owner only to enable his parents to obtain a mortgage, and that he should not thereby acquire a beneficial interest in 122 Church Lane, I would have rejected any claim based on the fact of contributions by Jim. In my judgment, no resulting trust, and when we say no resulting trust, we're talking about a constructive trust. Well, that's what I possibly that's what I can acquire, basically, because a resulting trust could have arisen like should have arisen like at the purchase of the purchase of the property. So no resulting trust should be presumed in favor of Jim. And when he says resulting trust, he means a constructive trust based only on financial contributions. Um, Secondly, I'm reading on paragraph 121. Secondly, I have found that the major part of the increase in borrowings was Jim's idea and was prompted by Jim's desire to buy a car and pay off his student loan. Although he and his father shared equally the surplus amount borrowed, the fact remains that Jim received a personal loan at better rates, that unsecured borrowing rates for his personal benefit, and it's not unnatural that it should have been felt right that he should make contributions towards its costs. It was not part of the joint venture of purchasing 122 Church Lane and improving it. So the judge found that he only relied on his on the first mortgage. There was no documentary, right, for Jim there was no documentary evidence to prove that he had paid anything towards the first mortgage. The second mortgage, it was his idea, and that he only felt that he had to contribute once the the price of £12,000 was raised for his benefit. No, we don't really know when he started contributing, right? But towards the second mortgage, the judge says that he only started contributing towards the second mortgage when the £12,000 was raised for him. But in the light of the fact that he was the one who started it all, he was the one who raised the idea. What would prevent the judge on his separate finding from finding that he raised the idea in order to contribute towards the property, so and therefore as a result acquired like a proprietary interest. But the whole thing, like the solution lies with paragraph 121, independently of the other two reasons, where it says I have found that the major part. Secondly, I have found that the major part of the increase in borrowings was Jim's idea and was prompted by Jim's desire to buy a car and pay off his student loan. So, and this is what purely financial contributions conduct, which under Stack versus Dowden, and Jones versus Kernot, it's it could be conduct that's actually from which it can be common intention could be inferred for a constructive trust to arise. That he's that it is not really easy, right, to prove that some contributions, some counter contributions are there and they're not alone. So some contributions are basically for the purpose of acquiring an interest in the house. An inference, such as Martin Dixon says, is just an inference. And through conduct, basically that which is financial contributions, direct financial contributions towards the purchase price of the house. Mortgage installments do suffice as direct financial contribution towards the purchase price, not for the purpose of resulting trust. Remember, even though in Lasker versus Lasker, there seemed to be that confusion there as well. But those are this is a constructive trust case. Resulting trust only at the purchase of the property. When the property is purchased, that's when they arise. Even though they overlap with the constructive trust quantification sometimes, not necessarily. So the judge basically rebutted that inference when he found that the major part of the increase in borrowings was Jim's idea and was prompted by Jim's desire to buy a car and pay off his student loan. So there you got it. Even that separate finding, it can be argued quite intelligibly stated by the court, the judge, that hey, you know what, he borrowed under, it was his idea to borrow. Not only was he trying to evade the second mortgage because he knew he had a flaw in his case regarding that mortgage, but even if he had made mortgage installments incorrectly, yes, someone would have thought the mortgage installments pertained to not the £12,000 which was given to him out of the surplus, which was divided equally with his father, but for the entire £50,000 which was taken in order to discharge the first mortgage. But the intention behind that was not for him to acquire an interest in the house, a share in the house, but in order for him to to get a beneficial loan and to buy his car and pay off his student loan. So this inference was rebutted, even if it could have risen However, the common intention that he should have had no interest in the house was just there. But in the separate findings, that separate interference was rebutted independently of the non-common intention. So, uh, independently of not that common intention, but we see that it's not really easy to acquire proprietary interest. And when the inference is rebutted, the next assumption is that the payment was either gratuitous, um, there was an intention to benefit basically the other person, or it was either um, was made as a loan. And well, in that case, let's say that the payments were either gratuitous, right, or they were actually made installments under the second mortgage were actually made in return of that loan. Um, and now consider, let's say that um, so there was no change in the circumstances. I mean, had this been proven, then he would have maintained his equal shares. Now, had there not been a common intention there, under Jones versus Kernot, he could have either maintained his equal shares if he had shown that he had paid like a part of the mortgage installments under the joint beneficial ownership, or he could have been awarded like a constructive trust, because the intention of the parties was that they would want to hold the property as otherwise, a constructive trust. Now, if the mortgage contributions were like insubstantial, and there was nothing before the court to see under a hypothetical scenario, because both parties were like not credible witnesses. So if it was that the only issue was the financial contributions, there was no common intention that he should have not an interest in the house. Would like meager contributions like count for him? Because, or would it not count? But would it count as for him to actually maintain an equal share in the property, or at least afford him some kind of a constructive trust quantification based on his detrimental reliance? Well, detrimental reliance needs to be substantial, for one. And because of that, frankly, I don't think he would have got anything. It would have counted as a loan. That could not actually qualify as conduct, right? So if we read paragraph 8, we found actually that the mortgage contribution were not part of the joint venture of the house, the purchase of the house. And then we go to paragraph 82. It says, similarly, payments made towards mortgage installments on an occasional basis or commenced sometime after the original acquisition would not have the requisite direct nexus with the purchase to be treated as a contribution to the purchase price, such as to result in the contributor acquiring commensurate beneficial interest. Now, this one is a bit tricky, because supposedly in a hypothetical scenario, someone has paid I don't know if he refers only to mortgage installments or post acquisition payments, because suppose that someone pays someone actually pays a lump sum of like 2/3 or like the entire lump sum, in 2 months, 2 months after like 6, 7, 10 years throughout the entire course of the mortgage, loan, right? And he pays the last 2 months and he discharges the mortgage. He has paid like 2/3, and let's say the court has only this kind of conduct, only this financial contribution in front of it, either in the form of admissions or by proof. Now, why should that not count as a post-acquisition contribution to the towards the purchase of the price? Why should the timing not form a requisite direct nexus? And the on paragraph 8, that's just for future reference. On paragraph 8, um, answering whether a joint mortgage uh, liability, I mean, being a joint mortgagor with someone over a house which is purchased, through that mortgage, or like a house which is a house a house which is used to to take out a mortgage, and the product is raised in order to is actually funding the purchase of another house, which goes under the name of the joint legal mortgagors of another house in that respect too. Um, that's the fact of being joint legal mortgagors, and joint legal owners mean, that they have bought a house together, and they are joint beneficial um, joint beneficial owners, tenants. Now it says no, it doesn't. That doesn't mean just by being exposed to the risk of mortgage liability, joint mortgage liability. That doesn't necessarily mean that you're responsible for it. What you need to show is that, what is really key is responsibility to pay the mortgage. And how is that shown? If there's nothing else before the court, that's actually shown without more. That's actually shown through payments of the mortgage installment. So if one party hasn't paid a dime under the mortgage installments without more, if that is the only factor that can be assessed as conduct through which a constructive trust can be inferred, right? I can see no much luck. Under Jones versus Kerner, that could qualify as an ambulatory constructive trust, which states, which would find that there was a change in the circumstances. The intention that they would have purchased the house together, right? Changed throughout the course of the relationship. It basically changed, and that's that they, that their beneficial shares would not reflect their joint liability, because their responsibility is manifested, is basically demonstrated in the form of making those payments. And that's the only thing in front of the court for that hypothetical scenario. So the other party, his beneficial share will be extinguished by possibly a constructed trust from the other person, who would just claim the lion's share, who would just claim, could even claim 100%. I remember in John versus Kernet, it was 10% because the other party had contributed something. Have contributed nothing, it's almost equal as a resulting trust, post-acquisition resulting trust, even though that term is wrong. And I'm reading from paragraph 8. The ordinary prima facie presumption will be that as between joint legal owners who have both undertaken joint and several liability under a mortgage taken out to fund initial purchase, each has provided a relevant contribution resulting in an equal share. See Carlton versus Goodman and Springett versus Defoe, 992 to FLR 388, and also read Gorman within italics a bankrupt, within brackets 1990 to FLR 284. However, that presumption may be dislodged either by contrary agreement, Springett versus Defoe, or by evidence that it was not intended as between the claimant and the other mortgagors at the time of the initial acquisition and the mortgage to fund it, the claimant should actually pay installments. In other words, paragraph 18 states, if the parties have agreed to the contrary, or if it is shown that the claimant has simply lent his or her name, such as was the case in Mackenzie versus Mackenzie and Carlton versus Goodman, in order to secure the mortgage advance, but without an intention of being liable as between himself or herself and the other mortgagors for repaying installments, the claimant will not be considered to have made a relevant contribution. This is notwithstanding having become potentially liable under the mortgage to the lender, the mortgagee basically, Carlton versus Goodman. Indeed, even payment made upon subsequent enforcement of that liability would not constitute a relevant contribution. It would not be a contribution to the purchase price, but rather a contribution to the discharge of the mortgage liabilities. So, as you can see, the only thing here is like the direct nexus. Was interestingly enough, like when actually mortgage installments come at a later stage, this is I can't see that being answered comfortably, if I can use that term, because in his separate finding, independently of the fact that had there been no common intention, had there be a common intention for him to have an interest in that property, considering the fact that he made the payments, and if he had, if it wasn't his idea, and if he had actually made the purchase, if it was proved that he had made the payments with intention to contribute towards the purchase of the house, then it's not basically discussed by the judge that the later stage would have affected him. So I'll just leave a little question mark there. And then that, in Lasker versus Lascar, same case was basically issued. In Lasker versus Lascar, the same facts. No, in Lasker versus Lasker, the same principle was basically not so much discussed. Lord Neuberger, in his judgment, at paragraph 21, says something similar to what was actually said in paragraph 80, with regards to the joint legal mortgage liability and responsibility in paragraph 81. He states, basically the house was bought as a joint venture there. There was no issue as to the, there was actually no issue there with regards to any common intention, and none of them would have had a interest in the house. But what was the issue there was the quantification of the beneficial interests of the parties. Mother and daughter had purchased the house. It was a joint venture. That was a common finding, common ground, and they were presumed to be like joint beneficial owners. Equity follows the law. The mother paid all repairs, handled all the rents. There was disputing the parties that led the appealant to seek to realize the interest in the property, and on account of the rental income received in court, the trial judge ruled that the appellant had 4.28% interest purely on the basis of the sum she contributed to the deposit, and that no account of rent should be made. Now, in that case, though, there was a resulting trust based on their contributions, but this was really not a resulting trust. It was basically a constructive trust, basically quantifying the parties' giving effect to the parties' intention that they would have had a joint beneficial ownership, joint legal ownership, joint beneficial ownership, and holding in equal shares, because they funded the house through the mortgage under which they had mortgage liability, joint legal mortgage liability, and the house was basically the mortgage installments were paid directly from the rent that was generated by the house. So by that enterprise. They seem that conduct seem on that conduct based on that conduct, they seem to be responsible. There was intention that they would be responsible, both of them, and because of that, they were awarded the beneficial shares were like not really 50-50% basis, like a 33% basis, because the contribution the house was bought under the house was actually bought under a discount, a rights of discount, which the mother was entitled to. It was a 33%. So the daughter got a substantially higher interest rate that what she had gotten under the first judgment, owed to like a false um, finding, false impression by the judge that because the the mortgage was basically paid by the mother, that she was actually paying the mortgage installments, which that's she was actually acting as the agent of the daughter, and that's why she was actually paying it. She wasn't only paying like paying the rent. The rent was the house. The rent was for the joint purpose of both. So it was only right that it should go towards the mortgage installment on behalf of both the purchasers. And in paragraph 21, he says, he goes on and he says the predecessor in title, let's say, if I can say in that sense, of what was later on said in Joan versus Kernod, the ambulatory trust. He actually uh, lay the foundations by saying, accordingly, even if the presumption of equality laid down in Stack versus Stack does apply in this case, or even if the presumption of advancement could apply, it seems to me that for the reasons I have given, either presumption would be rebutted on these facts. Accordingly, as in Stack, as explained by Lord Hope in paragraph 11, I can see no reason not fall back on the resulting trust analysis, namely that in the absence of any relevant discussion between the parties, their respective beneficial shares should reflect the size of their contributions to the purchase price, subject to any subsequent actions or discussions having the effect of varying those shares. So there you go again, um, he this paragraph shows that um, their respective beneficial in the absence of any relevant discussion between the parties, their respective beneficial shares should reflect the size of their contributions to the purchase price. So there you go. It's like the ambulatory constructive trust is what was said in paragraph 8081 of Mackenzie versus Mackenzie, that joint mortgage liability is not the end, is not the conclusion, right? There needs to be conduct there. Conduct could be in the form of payments and inferred common intention through that kind of conduct. Um, he then on states that it's like a resulting trust. He says that the respective beneficial shares should reflect the size of the contribution to the purchase price. Um, and this is There's a constructive trust. This is a it was supposed it was a resulting trust. A resulting trust, right? Um, in paragraph like 17, in the latter sort of case, a reason like that would not be appropriate, and the resulting presumption still appears to apply. But a resulting trust, though, he failed that resulting trust wouldn't apply because it was not a case of co-ownership where property is bought for living in living in such a stack and arm's length commercial case of co-ownership where property is bought for developmental letting. Well, in that sense, yes, it could be a resulting trust, but then again, in order not to be not to be confused, resulting trust arises at the time of the purchase of the property. That's what the fifth edition Holzer's Laws of England states, and it should be respected. And why not if it can arise on constructive trust? And if a constructive trust can give almost, if not an identical result to a resulting trust quantification. In that property, in that case, um, maybe he was more inclined towards a resulting trust because that's what it was simply a case where the property was bought for a joint venture, and as a joint venture, there was no other conduct that would have uh, would have shown indicated that the any other conduct other than financial contribution should be taken into consideration. However, the payments were post acquisition, and when there's post acquisition payments, like a lot of things can happen. However, a resulting trust, let's say that it was like a resulting trust post acquisition case. So I hope you enjoyed it. I was just trying to break down a couple of theories and principle, the way I understand them, and for you uh, to to understand them, and the way I grappled with them, and I did like for a long time. Subscribe to my this information is not legal advice, and should not be considered as such, and subscribe to my channel for more videos like that. Hope you enjoyed it. See ya.